You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Those 4 sentences are probably the most recognized legal phrases in the world. You have heard them in every police drama, every courtroom thriller, every arrest scene, and every movie made in the last half-century. They feel as old and as fundamental as the Constitution itself. But they are not in the Constitution. They were not part of any law passed by Congress. They did not exist anywhere in American law until June 13, 1966, when the Supreme Court ruled 5-4 in a case called Miranda versus Arizona and told every police department in the country that these words had to be spoken before a suspect could be questioned. For nearly 200 years before that ruling, American police had no obligation to tell you anything before they interrogated you. No requirement to mention your right to silence. No duty to warn you that your words could be used to convict you. And no instruction to inform you that you were entitled to a lawyer. If you confessed to a crime during an interrogation without knowing any of those rights, that confession could be used against you in court, and there was very little you could do about it. This is the story of how that changed. And it starts not with the Constitution, but with a practice that American police departments called the third degree. In the late 1800s and the first decades of the 1900s, police interrogation in the United States operated with almost no oversight and almost no rules. There were no recordings of interrogations, no requirement to document what happened during questioning, and no independent monitors to ensure that suspects were treated fairly. When a suspect was brought into a police station for questioning, what happened behind the closed door of the interrogation room was, for all practical purposes, entirely at the discretion of the officers conducting the interview. The only record of what occurred was the officer's own account, and if the suspect told a different story, the court almost always believed the officers. And in many departments across the country, what happened behind that door was ugly. The term third degree became the common shorthand for coercive interrogation techniques that were used routinely in police departments from New York to Los Angeles, from Boston to San Francisco, and in small-town police stations across the rural South and Midwest. The phrase itself originated in Freemasonry, where the third degree referred to the most rigorous examination a candidate could face. But in the context of American policing, it came to mean something far more brutal. At the milder end of the spectrum, suspects were subjected to marathon interrogation sessions that lasted 12, 24, or even 48 hours without interruption. They were denied food, water, sleep, and any contact with family, friends, or legal counsel. They were placed under blinding lights in small, windowless rooms for hours at a time, a technique designed to wear down psychological resistance through exhaustion and disorientation. Officers worked in relays, rotating fresh interrogators into the room while the suspect grew increasingly confused, frightened, and desperate to make the questioning stop by any means necessary, including confessing to something they had not done. At the more extreme end of the spectrum, the tactics crossed the line into outright physical abuse. Officers used rubber hoses to strike suspects because the hoses left fewer visible marks than fists. Telephone books were pressed against a suspect's head before being struck with a heavy object, causing intense pain without visible bruising. Suspects were handcuffed and left in stressed positions for hours. These techniques were not the actions of rogue officers acting outside the system. They were standard operating procedure in many of the largest police departments in the country, known to supervisors, tolerated by prosecutors, and almost never punished. The American public was largely unaware of how widespread these practices were until 1931, when President Herbert Hoover's Wickersham Commission published its findings on the state of law enforcement in the United States. The commission, chaired by former Attorney General George Wickersham, had been appointed in 1929 to investigate the administration of criminal justice across the country. Its 11 members spent 2 years gathering testimony, reviewing case files, and examining police practices in major cities and rural jurisdictions alike. The commission produced 14 reports covering every aspect of the criminal justice system, but it was report number 11, titled Lawlessness in Law Enforcement, that dropped like a bomb on the national conversation. The report's findings were blunt and impossible to dismiss. The commission concluded that the inflicting of pain, both physical and mental, to extract confessions from suspects was widespread throughout the country. The report documented cases in department after department, city after city, where the third degree was not an occasional excess but a routine practice. Investigators found that suspects were regularly held incommunicado for days, questioned in relay sessions that broke their resistance through sheer exhaustion, and subjected to physical abuse that the commission described in unflinching detail. The Wickersham Commission's findings generated newspaper headlines across the country and sparked public debate about the nature of American policing. But the report was advisory, not legislative. It resulted in no federal legislation, no binding reforms, and no enforceable standards for how police could conduct interrogations. The report was published, discussed, debated, and largely shelved. 5 years later, the Supreme Court took its first meaningful step toward limiting police interrogation practices. In 1936, the court heard the case of Brown v. Mississippi, a case that exposed just how far the coercion could go when there were no enforceable limits. 3 black men, Ed Brown, Henry Shields, and Yank Ellington, had been subjected to severe physical force by county law enforcement officials in order to extract confessions to a crime. A deputy sheriff and a mob of other men had seized Ellington and subjected him to prolonged physical abuse. When he refused to confess, they released him, only to seize him again days later for another round. Brown and Shields were similarly coerced at the county jail. The methods used were so extreme that even the Mississippi Supreme Court's own dissenting judge described them as a disgrace to the state and to the administration of justice. The United States Supreme Court agreed unanimously. Chief Justice Charles Evans Hughes wrote that confessions obtained through such methods were fundamentally unreliable and therefore inadmissible in court. The ruling established for the first time that the Due Process Clause of the 14th Amendment prohibited the use of coerced confessions in state criminal trials. Hughes wrote that it would be difficult to conceive of methods more revolting to the sense of justice than those used to obtain the confessions in this case. Brown v. Mississippi was a landmark ruling, but it had a critical limitation that would take 30 more years to resolve. The decision only applied to cases involving clear, extreme physical coercion. It only applied to cases involving clear, extreme physical coercion. It did not address the far more common forms of psychological pressure that police use daily in interrogation rooms across the country. The prolonged questioning sessions, the sleep deprivation, the deception, the implied threats, and the emotional manipulation that constituted the softer version of the third degree were not clearly prohibited by the ruling. Police departments adapted accordingly. Over the following decades, many departments shifted away from the most visible forms of physical abuse and towards psychological techniques that were harder to detect, harder to prove in court, and just as effective at producing confessions, whether those confessions were true or not. What followed was a 30-year period that legal scholars call the Voluntariness Era. During this time, from the late 1930s through the mid-1960s, the Supreme Court evaluated confessions on a case-by-case basis, asking whether each confession was made voluntarily under the totality of the circumstances. The test considered factors like the length of the interrogation, whether the suspect was given food and water, whether physical force was used, and whether the suspect had access to legal counsel. The problem with the voluntariness standard was that it was almost impossibly subjective. Every case was different. Every confession was evaluated on its own unique facts. There was no bright line that told police officers exactly what they could and could not do. What counted as voluntary in one courtroom might be considered coerced in another, and the burden of proving that a confession was involuntary fell on the defendant, which meant that in practice, most confessions were accepted by trial courts regardless of how they were obtained. The system was built on a legal fiction. It assumed that a suspect sitting alone in a police interrogation room, cut off from the outside world, with no lawyer present and no knowledge of his constitutional rights, was making a free and voluntary choice when he agreed to answer questions. Meanwhile, interrogation techniques were becoming more sophisticated, not less coercive. In 1962, 2 former police officers named Fred Imbaugh and John Reed published a textbook called Criminal Interrogation and Confessions that became the standard training manual for police interrogators across the country. The Reed technique, as it became known, taught officers a 9-step process for conducting interrogations. The first step was to isolate the suspect in a small, bare room, removed from any familiar environment or support system. The interrogator was then instructed to present the case as though the suspect's guilt was already a settled matter, not a question to be answered. The next steps involved offering the suspect moral justifications for the crime, suggesting that what happened was understandable given the circumstances, and slowly reducing the psychological distance between confession and relief. The technique was explicitly designed to overcome a suspect's resistance by making confession feel like the path of least psychological pain. The Reed technique was taught in police academies across the country and became the dominant method of interrogation for decades. Its defenders argued that it was an effective and lawful way to obtain truthful confessions from guilty suspects. Its critics argued that it was devastatingly effective at producing false confessions from innocent people who simply wanted the pressure to stop. Research conducted in later decades would show that certain populations, including juveniles, people with intellectual disabilities, and people with mental health conditions, were particularly vulnerable to the psychological pressure the technique applied. But in the early 1960s, none of that research existed, and the Reed technique was the law enforcement establishment's answer to the question of how to get confessions without leaving marks. Two Supreme Court cases in the early 1960s signaled that the court was moving toward a more definitive solution. In 1963, the court ruled in Gideon versus Wainwright that the Sixth Amendment's guarantee of the right to counsel applied to all felony defendants in state courts, not just in federal cases. Clarence Earl Gideon, a 51-year-old drifter with a fifth-grade education, had been convicted of breaking into a pool hall in Panama City, Florida. At his trial, Gideon asked the judge to appoint him a lawyer because he could not afford one. The judge refused, citing Florida law, which only provided appointed counsel in capital cases. Gideon was forced to represent himself, conducted his own cross-examinations, and was convicted by the jury in under an hour. From his prison cell, Gideon wrote a handwritten petition to the Supreme Court on prison stationery, arguing that the Constitution entitled him to a lawyer. The Supreme Court unanimously agreed. Justice Hugo Black wrote that any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. The Gideon decision established the right to a lawyer at trial, and it transformed the criminal justice system by requiring states to create public defender offices where none existed. But it did not address what happened during the interrogation that preceded the trial. A suspect could sit in an interrogation room for hours, without a lawyer, without any knowledge of his rights, and whatever he said during that time could still be used to convict him. The following year, in 1964, the court moved one step closer to addressing the interrogation room itself. In Escobedo versus Illinois, the court ruled that a suspect who had been denied access to his attorney during a police interrogation had been denied his Sixth Amendment rights. Danny Escobedo had been arrested by Chicago police in connection with a shooting. During questioning, Escobedo repeatedly asked to speak with his lawyer, who was in the same building, just down the hall from the interrogation room. The police repeatedly refused. Escobedo's lawyer even came to the door of the interrogation room and asked to see his client, and the police turned him away. Eventually, Escobedo made statements that implicated him in the crime. The court held that once a suspect requested a lawyer, the interrogation had to stop until the lawyer was present. But Escobedo was a narrow ruling that applied only when a suspect had already specifically asked for a lawyer. It did not require police to tell the suspect that a lawyer was available in the first place. If you did not know you had the right to a lawyer, you would never ask for one, and Escobedo would not protect you. The gap between the rights the Constitution guaranteed and the information suspects actually received in the interrogation room remained wide open. The stage was set for a case that would finally force the court to draw a clear line. That case arrived from Phoenix, Arizona, in the form of a 23-year-old laborer named Ernesto Miranda. If you're finding this valuable and want to see more deep dives into the hidden stories that shaped America, hit that subscribe button. We cover the history behind the systems and institutions you deal with every single day. Now, back to that interrogation room in Phoenix. On March 13, 1963, police in Phoenix arrested Ernesto Miranda on suspicion of a serious crime. Miranda was 23 years old, had dropped out of school after the 8th grade, and had a documented history of mental health difficulties and emotional instability. He had spent time in reform school as a teenager and had a prior criminal record, though nothing as serious as the charges he now faced. He was brought to the police station and placed in a lineup where the witness believed, but was not entirely certain, that Miranda was the person who had committed the crime. The identification was tentative at best, but the officers told Miranda that the witness had positively identified him, which stretched the truth of what had actually occurred in the lineup room, and took him to an interrogation room on the second floor of the station. For the next 2 hours, 2 Phoenix police detectives questioned Miranda in a small room. The detectives were experienced interrogators. Miranda was not an experienced suspect. He had a limited education, limited understanding of the legal system, and no one advising him. At no point during the interrogation did anyone inform Miranda that he had the right to remain silent, that anything he said could be used against him in court, that he had the right to have a lawyer present during questioning, or that if he could not afford a lawyer, the state would provide one. Miranda signed a written confession. At the top of the confession form was a typed paragraph stating that the confession had been made, with full knowledge of my legal rights, understanding any statement I make may be used against me. The paragraph was boilerplate, printed on every confession form the department used. Nobody had ever explained to Miranda what those legal rights actually were. The form said he understood his rights. The reality was that nobody had told him what those rights were. Miranda was convicted at trial. His court-appointed attorney, Alvin Moore, was a 73-year-old lawyer handling one of his final cases before retirement. Moore was competent, but outmatched by the prosecution, and he lacked the resources to mount a comprehensive constitutional challenge. He objected to the use of the confession at trial, arguing that Miranda had never been properly informed of his rights. The trial judge overruled the objection, and the jury convicted Miranda based largely on the written confession. The Arizona Supreme Court upheld the conviction, finding that Miranda had not specifically requested an attorney during questioning, which under the Escobedo precedent meant his rights had not been violated. The American Civil Liberties Union took up Miranda's appeal, recognizing the case as an opportunity to push the Supreme Court toward the clear, enforceable standard that the voluntariness test had failed to provide. Attorneys John Flynn and John Frank, both from the prominent Phoenix firm of Lewis and Rocha, agreed to argue the case pro bono before the United States Supreme Court. Flynn, a skilled trial lawyer, would handle the oral arguments. Frank, a constitutional scholar and former Supreme Court clerk, would develop the legal strategy. The case was consolidated with 3 other cases involving similar issues: Vignera versus New York, Westover versus United States, and California versus Stewart. All 4 cases involved suspects who had confessed during custodial interrogation without being adequately informed of their constitutional rights. By hearing the cases together, the court signaled that it was ready to address the interrogation question comprehensively rather than continuing to chip away at it one case at a time. Oral arguments were held over 3 days in late February and early March of 1966. Flynn argued that the Constitution required police to inform suspects of their rights before questioning, not merely to refrain from beating confessions out of them. The state of Arizona argued that Miranda had confessed voluntarily and that requiring specific warnings would impose an unworkable burden on law enforcement. On June 13, 1966, the Supreme Court issued its ruling. Chief Justice Earl Warren, writing for 5-4 majority, declared that the Fifth Amendment's protection against self-incrimination required police to inform suspects of specific rights before any custodial interrogation could begin. Warren's opinion was detailed, running over 60 pages, and it drew extensively on interrogation training manuals, including the Reed Technique textbook, to demonstrate that modern interrogation methods were designed to create a psychologically coercive environment that undermined a suspect's ability to make a free and voluntary choice. The court specified in language that would become the most quoted words in American criminal law that before any questioning, a person in custody must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. If the suspect indicates at any time that he wishes to remain silent or that he wants a lawyer, the interrogation must stop immediately. A suspect may waive these rights, but the waiver must be made voluntarily, knowingly, and intelligently, and the prosecution bears the burden of proving that it was. The 4 dissenting justices argued that the majority had gone too far and had imposed an unnecessarily rigid rule on law enforcement. Justice John Marshall Harlan wrote that the decision would have a corrosive effect on the ability of police to solve crimes and protect the public. Justice Byron White warned that the ruling would return a not insignificant number of guilty suspects to the streets, and that the majority was prioritizing abstract constitutional theory over the practical needs of law enforcement. Police chiefs and district attorneys across the country echoed these concerns in press conferences and public statements, predicting that the Miranda warnings would cripple criminal investigations, flood the courts with appeals, and allow dangerous suspects to escape justice by simply invoking their right to silence. Those predictions did not come true. Studies conducted in the years following the Miranda decision found that the warnings had a minimal effect on confession rates. The initial research conducted in cities like Pittsburgh, Washington, and Los Angeles showed that roughly 80% of suspects waived their Miranda rights and agreed to speak with police even after being warned. The warnings did not prevent police from obtaining confessions from guilty suspects. What they did was ensure that suspects understood the choice they were making and that any resulting confession was genuinely the product of a voluntary decision rather than ignorance or coercion. The Miranda decision also survived repeated legal challenges over the following decades. In 2000, the Supreme Court reaffirmed Miranda in a case called Dickerson versus United States, ruling 7-2 that the Miranda warnings had become such a fundamental part of American law and culture that they could not be overturned by an act of Congress. Chief Justice William Rehnquist, who had been critical of Miranda throughout his career, wrote the majority opinion, acknowledging that Miranda had become embedded in routine police practice to the point where the warnings had become part of the national culture. The Miranda warnings also had an effect that the court may not have fully anticipated. They entered American popular culture with a speed and thoroughness that no other legal concept has ever matched. Television shows began including the Miranda warnings in arrest scenes almost immediately after the ruling. The police drama, Dragnet, was among the first, and by the 1970s the phrases, "You have the right to remain silent," and "anything you say can be used against you," had become fixtures of every law enforcement show on television. The Miranda warning became the most instantly recognizable scene in American entertainment. Today, surveys consistently show that the Miranda warning is the single most recognized element of the American legal system, better known than any specific clause of the Constitution itself. Polls have found that more Americans can recite the Miranda warning than can name any of the rights guaranteed by the First Amendment. Ernesto Miranda's own story did not end with the Supreme Court ruling. After his conviction was overturned, the state of Arizona retried him. This time, prosecutors were forced to build their case without the written confession that had been the centerpiece of the first trial. They relied on witness testimony, circumstantial evidence, and a statement made by Miranda's common-law wife, who testified that Miranda had admitted the crime to her. The jury convicted Miranda again and sentenced him to 20 to 30 years in prison. He was paroled in 1972 after serving roughly a third of his sentence. After his release, Miranda lived quietly in Phoenix, earning money in part by selling autographed Miranda warning cards for $1.50 each, a strange footnote to one of the most important legal cases in American history. The story of Miranda rights is not a story about one case or one criminal defendant. It is a story about a country that took nearly 2 centuries to answer a question that should have been straightforward from the beginning. If the Constitution guarantees you the right to remain silent and the right to an attorney, does the government have an obligation to tell you that those rights exist before it tries to get you to give them up? Does a right that you do not know about actually protect you? For 177 years, the answer was no. The rights were on paper written into the Fifth and Sixth Amendments, but nobody was required to tell you about them. Police officers were trained in how to extract confessions, not in how to protect the rights of the people they were questioning. If you did not know you had the right to remain silent, you talked. If you did not know you were entitled to a lawyer, you answered questions alone in a small room with experienced interrogators who knew exactly how to make you say what they wanted to hear. And if the confession you signed was used to convict you, the legal system's position was that your ignorance of your own rights was your problem, not the government's. It took a presidential commission that exposed the scope of the abuse but had no power to fix it. A series of Supreme Court rulings that chipped away at the problem one case at a time over 3 decades, an underfunded civil liberties organization willing to fight a case all the way to the highest court in the land, a 23-year-old laborer who became the unlikely face of a constitutional revolution, and 5 justices willing to draw a clear line where their predecessors had drawn only vague boundaries. None of them alone could have changed the system. Together, they created 4 sentences that transformed American law enforcement, entered the vocabulary of every English-speaking person on the planet, and became so embedded in the culture that they feel as though they have been there since the beginning. The next time you hear those words on television, in a movie, or in any other context, remember that they are younger than the space program. They did not exist when your grandparents were young adults. And for nearly 2 centuries before they were spoken for the first time, the only thing standing between a suspect and an involuntary confession was the conscience of the officer sitting across the table in a locked room, with no recording, no lawyer, and no one watching.